When a couple's urgent need for estate planning documents faced delays, we revealed how life can change in an instant. With dedication and persistence, we ensured that they were protected before time ran out.
Can you describe this client that came to see you and what brought them in initially?
Sure. It was actually the financial planner who brought them in, and we work very well and closely with financial planners because part of what they do is to talk to their clients about estate planning and planning for their assets for what happens when they retire and pass away. So in this case, it was a married couple in the 60s who came and saw us. They had a will from 30, 40 years ago, and it was time that they updated their will and also then looked at other instruments such as an enduring power of attorney. And so it was important that we met with them and went through the process to get those things sorted out for the client. So the first step in our estate planning journey is to really sit down with the client, give them a questionnaire to understand what their intentions are, who the executor is, any guardian for children, who the beneficiaries are. And so once we collate all of that information through the questionnaire, through interviews, through etc., we would then start preparing the documents. So in this case, we took the time, we had a number of meetings, we obtained all of the information, and then we went away and prepared the estate planning documents. But then what happened was, after we prepared the documents and we sent it to the client, and then we asked the client to review it and also then let us know if they've got any other comments or changes, or otherwise, let's organize a time to sign the documents. We never heard back from the client. And it wasn't just because, we just sent it to him and didn't follow up, but we followed up with emails, telephone calls, we followed up every month. But, the clients had different things going on in their lives and really put it off, and it wasn't done.
And so with them not having signed the documents, did that mean those documents were essentially not valid?
Definitely, yeah. So it meant that, it wasn't valid. They didn't have those documents in place. Because what happened in this particular matter was then the wife's health took a turn for the worse. And actually, she had cancer, and it was quite a aggressive cancer. And then that meant that she was going to be in hospital. And it meant that, while all of this was happening, and she was, say for example, undergoing chemo and physically and mentally very drained, then it's going to be very difficult for them to sign and put the tension here, right? But this was the exact time when they needed to have their will and power of attorney and enduring guardianship in place. And it wasn't, which was quite sad. We were very saddened when that happened because obviously it's a very sad situation for anybody. But we had worked very closely with this client. We were quite fond of this client as well. And so what was very fortunate was then the client was able to get better and the cancer went into remission. And then when they were better, they then came back to us and said, Yuri, we've really got to sort this out. And I said, yes, we do. And they were able to come in and they were able to sign documents, and which, it gave me a lot of peace of mind and gave them and their family peace of mind as well. So I was really satisfied with that.
In this case, it was, they got lucky, she went into remission, she was able to sign the documents and get it over the line. But what would have happened if that wasn't the outcome of the case? What would have been the outcome then?
Great question, and the outcome there meant uncertainty, basically, is the answer. Because then there's a real question whether this will we prepared for them can be counted as an informal will versus the will that had in place 30, 40 years ago, right? So that's the first thing. Instruments like the power of attorney, if you don't sign it, that means it's not valid. It means that you can't grant attorney to the husband to manage financial affairs. So say they had to sell a house, sell a property to fund any of the health and medical treatment, then it was going to be harder to do so. Similarly, with the enduring guardianship, if the wife had lost mental capacity, testamentary capacity, then it was going to be more difficult for the husband to make decisions for her because they didn't have these documents.
Okay, so then I guess what are the key takeaways from this case? What can viewers take away from this situation?
The key takeaway is make sure you have your estate planning in order, have your will, enduring power of attorney, enduring guardianship, and potentially advanced care directive, if required, signed and in place. Because then that's going to give you peace of mind. Don't put it off. You never know what's going to happen. And, even in this case where they're older couple, people's life is always busy. And by, human nature, sometimes you don't want to think about difficult things and you always want to put things off because you think we're always going to be around, right? And we can always deal with it another day. So if I could give one piece of advice, which is get it sorted, get it in order, because that's going to give yourself peace of mind and give your family peace of mind.